Good evening. I think we'll kick off. We've got a full agenda this morning. This evening, my name is Alex Brownlee. I'm head of EthiQal. I'll be sort of hosting, running the introduction and then the Q&As at the end. I'm excited to present or host this webinar on the POPI Act. We'll do that in two sessions. The first session is hosted by Esme Prince. Esme Prince is well known in the healthcare space. She's a qualified attorney specializing in health law, and I think we've seen her in many sort of presentations and workshops and all the great work she's been doing. She'll be sort of launching off with a short presentation just to set the scene, set some context, and that will just allow us to set up the next session. That'll be managed by Dr. Hlombe. He is part of our specialist or clinical risks management team. He's a general practitioner with a master's in medical law and ethics. He'll be sort of in a more casual approach discussing the POPI Act as in a more practical way as it applies to healthcare practitioners. He'll be doing that with JP Ellis. He's head of our legal and claims department in EthiQal, also an attorney and specializing in the medical professional indemnity space. So really between Hlombe, JP and Esme, the second half of our webinar will be a much more relaxed and conversational style, trying to really get into the practicalities of this new act for healthcare practitioners. This will also then address some of the many questions that have been sent, so thank you very much for that. In terms of this webinar session, if there's a Q&A button at the bottom left or bottom middle of your screen, please send through any questions in that Q&A button, not the chat button. The Q&A, I'll be monitoring that, and at the end of the session, if we haven't covered it, I'll just manage that process and ask the questions to the panelists. In terms of some other housekeeping, we've got an hour for this webinar. That is one ethics legal CPD point. So we'll be providing those certificates probably next week. So please do provide through your MP number, your registration number. But I do feel like we probably might run over. So we probably, I'm just thinking, looking at the questions that have come through and sort of the more practical, relaxed style in terms of the discussion, we might run over an hour. Please don't feel bad if you need to leave after the hour. I think we'll carry on, probably aim for an hour and a quarter just to make sure we cover all the questions that we have received. But I'll keep running it till probably an hour and a quarter, and we'll try and end it then. But as I said, if you need to leave, please don't feel bad, please do. Okay, I think I've covered all of the housekeeping. Welcome again to everybody. And I'll hand over to Esme for your presentation. Esme.
Thank you, Alex, and good evening, ladies and gentlemen. Thank you for this opportunity to share some thoughts with you on the POPI Act. I'm just confirming that you can see my screen. Alex, you can maybe just give me an indication.
Yes, perfect, thanks.
Thank you very much. So I'll be brief in terms of my introduction and providing some context. I'm sure you have attended some POPI presentations before. So there are not many days now before the Act will actually become enforceable. So it's already law, but on the 1st of July this year, it will become enforceable, which means that the information regulator can impose penalties under the Act, and the courts can actually enforce the Act. Non-compliance with the Act will and could have significant consequences for practices, and I'll briefly touch on that a little bit later. So what is this all about? In the Constitution, we have a right to privacy. Now, the right to privacy is multifaceted. It has many layers. One of these layers deals with personal information. So it's an aspect of our right to privacy, and POPI will actually regulate the processing of personal information. So what is the processing of personal information? When we use the term processing in terms of POPI, it actually means anything that you can do with personal information. When you collect it from a patient or another practitioner, when it is sent to you, you just receive it, you use it, Even when you store it, you're actually processing information. When you disseminate that or actually delete or destroy the information. So it's quite a comprehensive concept in terms of what processing actually entails. Personal information includes information like age and gender, address, contact details, health information, preferences about a person, even an opinion about a person. The name of a person is not always protected. It depends on the context, what information is actually revealed with the person's name. Now, we're talking about personal information of data subjects. So you need to understand who are the data subjects in your practice, because it's their personal information that you need to protect. Now, a data subject is a living human being. We're not talking about deceased persons, deceased individuals, and also legal or heuristic persons. So what is a legal or heuristic person? It's, for example, a company. Medical schemes are heuristic persons. Regulators are heuristic persons. So even if you have information of such entities or bodies, they have personal information that is protected under POPI. Now, in terms of the enforcement of the law, there is the new regulator in place, the information regulator. Now, the regulator is immediately at the moment already responsible for the management, the enforcement, the implementation of POPI, which I've already addressed in terms of the constitutional right to privacy. Then there's another law, I'm sure you're well aware of it, called POPIA, the Promotion of Access to Information Act. This law has been a law since the year 2000, so already 21 years. And it actually regulates access to the records of personal information. And it gives effect to the constitutional right to have access to information. Now, currently, this law falls under the Human Rights Commission. But on the 30th of June, POPIA moves across to the information regulator. So effectively, from the 30th of June, the information regulator will be responsible for the enforcement of both these two information laws. And there's a clear correlation or interrelationship between these two laws. Both deal with personal information, and POPIA specifically around access. And POPI actually refers to POPIA in certain areas of the law. Now, if we talk about POPI, it actually creates a number of rights for data subjects. So remember now, data subjects, you must understand in the broader context of your practice. I'm just going to talk about it from a patient perspective. So patients are data subjects, and what are their rights under POPI? First of all, when you actually process their information, it must comply with 8 conditions for the lawful processing. When you collect information about them, they must be informed about that. If there's a privacy breach, they must be informed about that as well. The patient can come and ask you for access to their records, their information in your possession or under your control. They can ask you to make corrections to their information or ask you to destroy their information, their records, or delete the information. In certain instances, they may object to processing. They may object if you use their information for marketing purposes. They have the right not to be subject to automated profiling. There are certain conditions around that. And they may complain to the information regulator or even claim damages from a court of law, and you can't prohibit that. So if these are the rights that patients have or data subjects have, what are your obligations? So I'm just going to summarize them very briefly. So first of all, the buck stops with the practice or the practitioner. The practice is accountable under POPI for compliance. When you process personal information, POPI expects you to do so lawfully. It must be reasonable the way you process. It must be minimal. In other words, you only collect and process information that you need, and it must be justified. And I will explain the justification shortly a little bit further. When you collect information, it must be for a specific purpose. POPI deals also with record keeping, and I'll give you some information on that shortly. If you have information in your practice and you want to later on use it for another purpose, there are certain requirements under POPI for you to actually process that information further. You are responsible to ensure that you work with quality information, accurate information. You must have a POPIA manual in place in your practice and on your website if you have one. There are certain information that you must communicate to your data subjects, to your patients, give them notifications. There are requirements around security, and when there are breaches of security or privacy, that you have to inform the patient and the information regulator about those breaches. There are requirements around outsourced processing. When somebody, for example, prepares your invoices, that there must be a contractual relationship and the contracts must contain certain clauses. You have the obligation to provide access to records if your patients request those. You can only refuse if POPIA allows you to refuse access. You must also make corrections or do deletions from the information or the records in certain circumstances. When you send information across the borders of South Africa to third parties, there are also certain requirements that you have to meet. When you use patient information for marketing purposes, there are requirements, and you have to register an information officer. So you can see it's quite broad, quite extensive, your obligations under POPI. Now in POPI, every processing activity may only occur on a legal basis as listed in POPI. Now, what does that mean? What is a legal basis? A legal basis is, for example, a law, legislation that allows you to do a certain processing or do a particular processing activity. Consent of the patient is also a legal basis. Now, the different options depend on the type of personal information, the different legal bases. Now, why do I want to share this with you tonight? I think we must reflect a little bit on consent. So when do you need consent? I think in the past, our approach has been we get consent for everything, but I think consent has become quite difficult. So I want to just share with you what the law says. So in the legislation broadly, there are certain permissions for you to process information already. For example, you must keep medical records. It's an obligation in the National Health Act. That is a legal basis for processing, and you don't need the patient's consent for that. POPI tells us you can always process health and race-related information of patients if you need that for the proper treatment and care of patients. So you don't need consent for that. You can do it. The law gives you that permission, that right. You can also process health information for the administration of your practice. For example, to put ICD-10 codes on your invoices. And when you accept a patient in your practice, you are actually concluding a contract with that patient. And POPI says when you conclude contracts, you actually can process information such as contact details, addresses, ID numbers, the information you need to conclude and perform that contract. So for all those things that I've mentioned, you actually do not need consent. POPI also allows us in certain areas when we are not working with special personal information like health information or children's information, that you can sometimes process information if there's a legitimate interest of the patient or even a legitimate interest of the practice at stake. Now, when you use legitimate interest as your processing ground, then a patient could actually object to that. So essentially how you should approach it, one should determine what can you do in terms of existing legislation, and then ask the question, what else do you do with personal information of patients? For example, you will make certain disclosures to medical schemes or to other parties. And if that processing activity is not authorized by legislation, then only will you obtain consent. Consent is tricky. The definition of consent under POPI is that it must be voluntary. So in other words, somebody must be able to say no. It must be specific. So I must know what I consent to, and informed, what are you going to do with the information? Who must consent? That's a challenge under POPI, but in terms from a practice point of view, it's probably easier But if a child is of consenting age, where they can independently consent to treatment, they can actually independently consent to the processing of the information. Now, the problem with consent, other than that it's voluntary, is that consent can be withdrawn, and you can do nothing about it if a patient withdraws that. Then you must manage that. You must know who has withdrawn their consent. And you also, if you rely on consent, you have the burden of proof. So you must always be able to prove the consent. Therefore, I will only suggest that one uses consent in those areas where it's actually there's no other option because of the challenges we face with consent under POPI. In terms of record retention, POPI essentially says that you must keep records as long as you need it to achieve the purpose of the collection and processing of that information. And then you must destroy, delete, or de-identify the information. But POPI does give us other options as well. It says, for example, if there's a law that allows you or specify that you must keep information for a certain period, then you keep it for that period. If there's a lawful purpose, which you define within your practice setting, you can keep the information longer. If there's a contract, an agreement that you keep information for a specific period, you comply with the contract. You can also use consent. If you want to use the information for historical, statistical, or research purposes, you can also keep it longer. Or if you have used a record to make a decision about a data subject. Now, you will often do that, use your records to make a treatment decision. And POPI actually allows you to then keep the records longer. It actually expects you to keep it longer for a period that would allow your patient to come and ask you for access to those records. Now, what does that mean? POPI is not specific, so we have to interpret these kind of guidelines. And I think the Health Profession Council's guidelines in terms of how long you should keep records, you should definitely consider and actually apply. So what I want to say to you is there's not a specific time frame or a timeline after which you must delete. You have to define this in your practice according to the options in POPI. But when you've decided you delete after a certain period, you have to comply with that. So you need to consider a record-keeping policy for your practice. So what must you do to actually comply with POPI? This is just high level. So in your practice, you need to actually identify the lawful basis on which you process information or further process information that will allow you to know when do you require patient consent. When you collect information from third parties, it must also be justified in terms of POPI. It gives us grounds when you can collect from third parties, and you must tell patients and other data subjects when you collect the information from third parties. When you send information to third parties in foreign countries, you need to know what are you sending and are those countries safe from a data protection point of view. If they are not safe and you send, for example, children's information to that country, there's a specific notification process to the regulator, actually a pre-authorization process that you must follow. You must make sure that when you disclose information in your practice that it's authorized. If you use consent, it must be managed. Who has consented, who has withdrawn consent. You must only collect information that you require for purposes of your practice. So you actually need to look at your patient documentation. There are certain notifications, certain information that you have to communicate to patients and your other data subjects, like your employees. And a useful tool to do this is through a privacy policy. You have to have a record-keeping policy and only keep your records for as long as it's lawful. You must have a POPIA manual, that's a statutory requirement. When you outsource agreement or outsource processing, for example, if you have a bureau that does your invoicing, you must have a written agreement in place, and there are certain clauses that are prescribed that should form part of that agreement. Your employees should work under a confidentiality undertaking, and if you have persons that provide access or support to your practice, for example, on equipment or IT support, they should also be subject to confidentiality undertakings. There are certain processes that you must provide for in your practice that can actually be instituted under POPI, for example, where a patient come and ask for access to records or that you delete information or correct information. So you must be able to deal with these requests. If there's a privacy breach, you have to investigate that because you have to report these breaches to the regulator and the data subjects, that your patients. And when you receive requests for access to information, you must actually record them because you have to report on these requests annually to the information regulator. You must also be able to tell your patients with whom have you shared their information. So there must be a way of you recording this so that you can answer those questions. You must also make sure that you have secure record storage for your files, hard copy files, and electronic records. You need to look at the security of your systems and processes. And we're talking actually about people, processes, and systems. So what happens in your reception area? Can other patients overhear each other's personal information? Make sure that emails are sent to the correct people. Consider WhatsApp. A lot of healthcare practitioners use WhatsApp to communicate patient information, and WhatsApp is not a secure environment, and it's also information that's stored in other countries. System hacking is something that happens nowadays. So do you have backups for your information? You have to implement a compliance framework in your practice to deal with all these things that I've mentioned. The information officer, who might be yourself, must also do a personal information impact assessment. You must ensure that your employees have guidance on how to apply with the law and receive training. And you have to register an information officer for your practice at the regulator. So that is quite a mouthful, an extreme set of obligations that you have to comply with. So what is the downside of non-compliance? There's going to be a complaint process at the regulator, so anybody can go and complain. And if there is an offense committed, there can be an administrative fine imposed of up to 10 million rand. There's also the potential of your patient or another data subject going to court and claim damages from you, or also aggravated damages. There's the option of a criminal process for offenses with fines and imprisonment. I'm not too concerned about that. We don't see that often being invoked. So the first two for me are more of concern because it's going to be easy processes, and we may actually see that patients use this when the regulator starts with an awareness campaign around POPI from the 1st of July. And then lastly, the information officer and the head of the practice can incur personal liability. The enforcement committee can recommend enforcement action against the information officer under POPI. And under POPIA, there could even be criminal liability if one doesn't comply with the requirements around POPIA, the POPIA manual, and access requests. And all of this could lead to reputational damage. So where to from here? I think as health professionals, you are used to confidentiality requirements with the ethical rules and the laws. This is not new. But with technology and the interconnectivity of systems, and we've seen some abuse of information by persons and entities, globally, there's a move to the implementation of data protection legislation. And South Africa is actually going that route now with POPI. POPI actually raises the bar for the handling of personal information. The latest reports indicate that online cybersecurity threats globally exceed 600 per minute at present, which is a staggering figure. And we also see that the healthcare industry is at high risk, that people try to hack healthcare information because it's valuable. In the United Kingdom last year, over those 4 months, they actually identified phishing as the most common cybersecurity incident. So that's where somebody would click on an email with a suspicious link on it. And the most common cause of a data breach has been misdirected emails, where people have actually sent emails to the incorrect people. And those are privacy breaches under POPI, which must be reported. So by concluding, or in conclusion, it's not the intention, I think, of POPI to prevent you from conducting your practices. But the real risk is that your patients may actually use and abuse POPI. So hence we have to comply. And we are all humans, we make mistakes, and we need to try and minimize human error and make sure that there are processes in place. Compliance with POPI is not documents in a file. It's not a tick box approach that once you've done all these things, you are actually compliant. Yes, of course, you can use a tick box initially, but compliance with POPI is actually a cultural thing. Yeah, it must become integral to your practice in the way you practice dealing with documents, procedures, etc. within the practice. And remember that every person in your practice is important to achieve compliance. If you have a weak link anywhere in your practice, a person who does not understand what to do and how to comply, it actually poses an enormous risk to you in terms of penalties being imposed under POPI. I think on that note, Alex, I will stop now, and then we can probably move on to the discussion session.
Thank you very much, Esme. I think that was a great summary just to kick off and get us some bit of context and some insights, and I think some nice references to the healthcare practitioners space. I'll hand over to Dr. Hlombe now to sort of manage the next more relaxed discussion, touching on past questions, scenarios, etc. So over to you, Dr. Hlombe.
Thanks, Alex, and good evening to everybody. Thanks, Esme and JP. Listening to your presentation, I just didn't know exactly where to start. It seems like, from a health practitioner's point of view, it's going to be very difficult. I've got so many questions, I don't know exactly where to start, but I think if we look at the questions that we already received, I think you really touched on a few of those in terms of what is required for compliance. But maybe just a few things. Do we need, or do doctors really need to have documented processes in terms of a policy document, different consent forms, contracts for using with, say, medical schemes or to IT people or the other third parties? Is that what is required? I'm not going to say which one to answer, you guys will choose.
JP, do you want to, or should I?
So good evening to everybody. Yes, thanks, Hlombe. So yes, it does require a certain amount of additional administration in order to ensure compliance. And yes, there are additional documentation that one would have to have. I mean, my thought around that is really to almost facilitate having a POPI file or a POPIA and a PIA file in your practice, because one would have to think of it in the same way that an inspector from the labor department might come to inspect your practice and ensure that there's compliance with certain occupational health and safety guidelines. So one would have to demonstrate that there was certain training done, that you indeed have an information officer that's been appointed, that you have retention policies, the documentation and compliance requisites that Esme was mentioning. Those are things that one would have to demonstrate to ensure that you are compliant. But obviously, that's on the compliance side. The cultures has to be there, and that's the only way that you can demonstrate that you are compliant.
Just on that, maybe, Esme, you spoke about it. I mean, even JP now, you're talking about two things. One, the information officer that needs to be appointed. I mean, practices, you've got a one doctor practice with two people. Do you really need to appoint a person, or is it added responsibilities that would be given to a person? Does it have to be saying this one is our information officer? That's what that person does? Or can it just be added responsibility on existing people.
Yes, Dr. Schlambe, it's quite a challenge, especially if you've got a small practice. But by law, the head of the practice is actually the default information officer. That person, the head of the practice, may authorize somebody else as the information officer. So it depends on the practice setup and how many people you've got. So even if you as the head of the practice assume or accept that role and you don't appoint anybody else, you must still be registered with the information regulator. It's currently a very simple process. It's an online process, which you must do, and you immediately get a confirmation of your registration. You get a registration certificate. What you could consider is, you've noted in the little bit that I've said, but there are a lot more. It's quite a heavy burden, and there are quite a number of duties on the information officer, administrative duties. So you may want to consider even appointing or designating a deputy information officer in your practice, like a staff member, who can actually support you with these processes, because your primary concern is your patients and you want to treat them. So you don't want to be bogged down with administrative processes. So I think one needs to look at what's practical in your setup, the size of your practice, but I will definitely recommend that you do consider maybe either authorizing a staff member whom you think can do this job, or at least appoint a deputy who can actually assist you to discharge your responsibilities.
And is POPI going to be, you speak of information regulators, would there be a time when maybe an auditor from the information regulator could come to a practice and say, we're here to audit compliance to POPI?
I think that is a possibility. And just following on what Esme was saying, the website of the information regulator is quite helpful, and there's quite a lot of information there. But my understanding is that that is the intention. At some point, codes of conduct will be provided, furnishing better guidance as to what is expected in terms of processing information. But definitely there will be occasion when one could expect an unceremonious visit from someone at the information regulator's office, because keep in mind they enforce both the POPI Act as well as the POPIA Act, the Promotion of Access to Information Act.
I think that becomes very difficult for doctors, because remember that there is POPI now, there is promotion of access to information, there are guidelines on confidentiality. It's very difficult to have. Is there a simpler way? And I hear you guys talking of a POPIA manual, and I'm not sure if a lot of doctors understand or know what a POPIA manual is. Is there a simpler way of ensuring that you balance the confidentiality, the requirements of POPI, the requirements from POPIA? How can you do this thing in a very simple way? Or it's not simple?
Yeah, it's unfortunately, I think it's quite a complicated law with a lot of requirements, Dr. Schlambe. So first of all, in terms of confidentiality, so I don't think you're going to make major changes in your practice, but you have to make sure that when you disclose information, for example, that you are compliant with the law and that you've got that authority. And remember now, maybe in the past, you didn't necessarily shared your records with the patient. If the patient now comes and asks you for a copy of his or her records, it's going to be very difficult for you to say no, unless you can say no in terms of POPIA. So when you have a request for information, you must actually look at in POPIA if there is a reason for you to say no, and then you have to provide it if there's no reason. So that's where POPIA is going to come into play, when you are going to start providing information to either the data subject, the patient, or a third party on request. As to the POPIA manual, it is a statutory prescribed document. So certain practices already have POPIA manuals, but if you have one in place, you have to revisit it, because POPI has added information and fields of information that must be included in your manual. So if you had a manual compiled a number of years ago, it has to be updated. And essentially what the manual does is it tells your data subjects, your patients and anybody else, what are the types of records and information you have in your practice? Is there anything that's automatically available? And if not, how can they get access? What is the process? They need to use a form, they need to complete the form. There could even be fees charged in certain instances, but that is the function of the POPIA manual. And as I've mentioned, it must be at your practice and on your practice's website.
Maybe just to add, Shalomwe, too, because it's quite an important point. Both acts, the Promotion of Access to Information Act, as well as POPI, tries to strike a fair balance between the right to privacy versus the reasonable right or the right to reasonable access to information. So as Esme mentioned, POPIA is not anything new. It's already in our law. There are intended updates that will be provided to the regulations. I think there's even a section that provides for potential mediation by the information regulator. But fortunately, with many of our policyholders, that burden is taken away from them, because when they receive a request for records in terms of POPIA, we as the claims and legal department and EthiQal assist them with that. So we take that burden away when it comes to an information request in terms of POPIA. With regard to POPI, obviously, again, because it's such an important aspect, one has to make quite sure that you've got the necessary compliance and protocols in place, and that there's training so that your staff are aware of that. So both you and your staff need to be aware in certain instances that accessibility to information is required, because as much as those are your files, the actual content is the personal information that belongs to a patient. So they have that right to reasonable access to information.
And don't they? And if the patient requests his or her information, it doesn't have to go through the POPIA process. If I'm a patient and I want my information from you, the person that I've given to, I don't need to go through the POPIA process, do I?
What is interesting now is POPI actually says that when a data subject requests information, that they must use the form prescribed by POPIA, which is under review by the legislature at the moment. So POPI actually brings the POPIA process in play here. Whether practice are still going to have a formal, an informal approach, that's another consideration, but the law actually now pushes patients to actually complete that form, which will be probably a new form, so that you can actually assess what do they exactly want. Because let's say, for example, if you share their information with them, but it will also disclose a third party's information, let's say another family member, because that's how your records were done. You actually need to involve the third party before you disclose that information. So there you have to consider POPIA. So one should just be very careful in terms of such an approach.
I think we can discuss this for a long time, but in the interest of time, just want to ask a few questions. It's a very common practice that patients would phone a practice, or the front office in a practice will phone patients. If I'm sitting at the front desk and there's a phone call that is coming in, requesting information, or I need information from that as my receptionist is doing, do I need to have, when you phone the insurance companies, this call is recorded and we work under, do you need to have a disclaimer, which is like that when you receive every call? Because on a phone call, you can get personal information of the caller. Is that a requirement? JP?
So
is still
my view is that, sorry. So my view is that the operative word here is reasonableness. I would suggest that you adopt reasonable measures to ensure the safeguard of personal information. Now, it's not always possible to have it in that setting where it's a small practice, it's a small waiting area, there's a receptionist right there, there's a computer with a screen, files are on the desk. But what I suggest is one has to adopt a different mindset, in that you have to become more vigilant now. There's a reason why the operative person is referred to as the responsible party. You have to take responsibility for the personal information that you carry. So one has to be a bit more vigilant, be a lot more diligent with the information that you have. So I would suggest that whoever answers the phone needs to be trained with regard to how to handle that information, not to at a loud volume, indicate, okay, so-and-so has got, their test results has now been received and this is the test results. One has to be quite conscientious as to there are people in the waiting area, the information that you get. And if it's possible, take the call in a different room or an area, if that is possible. In most cases, it's not, but one has to just be very mindful of those things.
I think what I'm hearing here is that, when you visit practices these days, you see that the reception area has got a screen, a COVID screen. So you're saying that probably we need to have a soundproof screen, so that at least the people who are seated on the other side should not really hear what's being said.
Or not share details.
Or not share details. The other one that is also extremely important. I hear Esme talking about the data subject and processing of the data, and you have to inform the patient in this case of who you have shared his or her information with. It's not always practical, because in some cases you'd find the patient, you'd have to share this information with other health professionals, and you may not always know, upfront, or after sharing that information can be shared with other health professionals. For instance, you refer to a physician, the physician decided that actually this patient now needs a psychologist. How is that practical? How can it be prevented? How can you make it work? Or would you be found that you have, breached personal information protection?
Yeah, first of all, Dr. Schlombe, when you share information, obviously that must be authorized. So you must be able to do it lawfully. So that's one aspect. But in terms of the recipient, so the law allows the patient to come and ask you with whom have you shared the information. So that's a new requirement. Certain things will be straightforward. When you look at your patient records, you can see that you've submitted a claim to the medical scheme. So clearly you have communicated with the medical scheme. If there's a referral note on your file, you will know that you referred the patient or you shared information with the doctor to whom you referred that patient to, or the practitioner. But you are going to get these, I want to actually say exceptions, where you share information with other practitioners or other people, which must still be lawful, but somehow you would need to create a mechanism or start practicing it to make a note when you've discussed information or shared information with another person or another practitioner. Otherwise, you will never be able to discharge this responsibility or comply with this obligation.
Yeah, I really think the operative word here is the culture and the understanding of reasonableness, because it's not always going to be very practical for health professionals or practitioners to know that the information has gone. What happens if the third party you've shared the information with breaches the professional or the personal information? I've sent this to a lab. This is the information, went to a lab. Then the lab itself then breaches the requirements of protection of that personal information, remembering that this patient has given me the information. So who will be responsible?
So in that case, the lab would be an operator. So they would essentially be carrying out certain functions on your behalf. And as they are a third party, you would have to have some arrangement. Your contractual arrangement is most likely reduced in writing. but one would have to have some sort of safeguard in place where you do an impact assessment to review those contracts that you have with other third parties that you engage with regularly. And often what we look for is to have some sort of undertaking from them that they undertake to ensure adequate security, that they will safeguard the personal information, and to notify you if there is a breach, or to notify the information regulator and the data subject if there is a breach. But essentially the responsibility lies with that operator.
The other question that I have is, you always, or in many cases, you request the information of the next of kin. For an example, here is a patient in front of you. You know that the patient has given you his or her information, and you request the next of kin. That information, the next of kin information, is personal information of a third party that you're getting from the patient. Is that legal? Do we need to be cautious about that? Or do we need to say, please get permission from this person that you're giving me his or her personal information?
I think the most practical way to deal with this is to cover this in a privacy policy of the practice. And also in this policy to advise the patient, if you share information about anybody else, like your next of kin, you must have their consent. You must ensure that you have their consent and that they are aware how this practice actually processes information. There is also the ability in POPI to collect information from third parties. And one of the grounds is, for example, when it's not practical in the circumstances to get it from the data subject. And I think this is, for me, a classic example. So when you actually collect the next of kin information, it's practical for the practice to phone the next of kin and to get their information, or to find the next of kin for that matter. So for me, that is justified to collect it from the patient, but then to deal with the processing in terms of the practice's privacy policy.
Okay. I think the other question that is a practical question is, in busy practices, even if it's not in busy practices, routinely doctors would talk to their front office people to convey a message to a patient. Maybe to say, look, your doctor has informed me that you'll come back for your appointment, or not to worry, your results are not are negative, as an example. Is there caution that doctors need to take when they use their front offices to contact the patients?
So
because it's really not possible for doctors to always be the person who's phoning the patient.
Yeah, so I mean, in some cases you see practices sending out SMSs or emails. I think it's important to mention that one would always have to have the necessary consent to disseminate certain information. I mean, my suggestion would be that, as part of your take-on documentation, you'd need to have obviously certain relevant additions to that document to include things like sharing information either via social media and I'm talking now specifically what SMS or email. But for me, the important thing is, again, the reasonableness. The more sensitive the information, the more vigilance you have to take in order to send out certain information. I mean, there have been a number of cases where information is disseminated and it's sent out incorrectly or to the wrong person, or even by SMS. So if one has certain safeguards, for example, like you could encrypt a PDF document with the test results, then that should be followed if it's practical. Sending out an SMS, for example, to mention that certain test results are available, but to not necessarily communicate those results is probably preferable. And again, depending on the sensitivity of the information, to have certain follow-up, like a phone call, or just to verify that this is indeed, for example, the correct telephone number, the correct email address, so certain basic safeguards that can be easily implemented.
Maybe one last question from me, that then we would go to, I think there are several questions that have been posed already. Just one last question. There are occasions where a patient would request a doctor to write a report on the patient's medical report. Says, look, this is required by my employer. The doctor will write the report, either give it to the patient, depending on what the patient requested, or send it to the employer with the consent. And what happens if that employer, 3 months later, contacts the doctor directly and says, oh, you've given us so-and-so's report. How is the progress? Do you need to go back to the patient and say, do I need a fresh consent, or do I use the very first consent that this patient given me?
In my view, it first of all depends on what the consent exactly provides. But I don't believe in the consent forms that I've seen, it will be broad enough. So hence, if you're going to provide more information or further information, I think you should make sure that you are authorized to do so and that you have the consent for that.
And does this apply to the requirements, for instance, of, say, is there COIDA for these medical reports that may be required for road accident, or is it covered by law? Meaning that you don't need to get the consent when it's a occupational injury or something like that.
With occupational injuries, the doctors must provide certain information by law. So if it's according to that and related to the injury, I think it will be covered. And it's to the benefit of the patient also to be able to claim compensation or to receive benefits under the fund.
Right. I think we can just look at, I'm not sure if maybe you want me to choose the questions, or we could just go through all these questions and check if we can, deal with them.
Closed my video just to help with the sound. So just the first question on the Q&A section, it's really, what's the first step to really becoming compliant? I think you've touched on it a bit through, but maybe just to summarize, what's the first step? Is there a basic initial form? Ismay?
Yeah, it's a difficult one because you actually have to comply with the entire law. So the two things I will do immediately is to register the information officer and get the POPIA manual in place, because that is a statutory requirement that can actually result in criminal liability. So those are two things that get them out of the way. But unfortunately, you have to comply with the entire law. There's not partial compliance or proportional compliance. The next thing that I would look at definitely is my patient documentation and a privacy policy. But yeah, what is more important if you start looking at security and processes in the practice as well? So it's actually hard to choose. But as I say, I would at least do the first two things that I've mentioned to start the process.
Alex, maybe if I can just add to that. I mean, I agree with Ismay. It is difficult to find a starting point when one has to comply with the new act. And it is quite extensive. I mean, it's a 76-page document. But I mean, often what I've said to practitioners is, to adopt some sort of risk assessment process where you sort of go through your practice, looking at the source of information, et cetera, et cetera. So if it's okay with everyone, I just want to share my screen. I've just got a one-page slide that I would like to share. I'm not sure if it's
coming through now. There we go, we've got it. Although it's in the presenter view, JP.
okay.
You could
okay.
do it again. I can guide you. I'll just switch that off.
Hopefully that's easy to read, but it's basically just 10 points that I wanted to just mention. I suppose in a way 10 steps. I mean, the first thing that Ismay mentioned was to appoint an information officer. And that's quite easy. There's a link to the website you can go to, and it's a very straightforward process, and you'll get a registration certificate. The second thing is to look at access to information, all physical access to information, for example, patient files, to ensure that it's secured and accessed by designated staff only, and that you have the necessary computer systems in place to ensure access only by authorized individuals. 3, you need to have a privacy statement, as Esme mentioned. Looking at your patient registration forms or the take-on forms, you'll need to update that to include the necessary consents or relevant clauses to incorporate for purposes of compliance with POPI. Looking at the information quality, because one of the things that's required is to regularly update or ensure that the information is of a sound quality, so that you are updating the information. Because as point 7 says, accessibility, and that comes back to POPIA, a reasonable right of access to the information. A patient, if they require access to the information, it needs to be the correct information. If they're asking you to update certain pieces of information or the health status changes, that needs to be updated. 6 is a retention policy, just indicating, you know, how long you would keep your records. There are other reports on, for example, disclosures, in what instances you have made certain disclosures, to keep a record of that. And your retention policy I've mentioned already. Number 8, the third-party contracts, you deal with bureaus, labs.
Have you lost JP?
It does seem that way. I was not sure if it was myself or JP, but seems we've lost JP. Maybe we'll just quickly finish. So there's the list. We will be sharing that from our side and the EthiQal website, and some further support around this, including sharing this webinar on our website next week. So I think that just for time-wise, I think we should move on. Should we do the next point? Maybe just on that prior point, the website to register as the information officer has been shared in one of the questions and answer section. On to the next question. I think this talks to how do we treat a patient in trauma at, say, 2 o'clock in the morning. Maybe Chlombe, do you want to start? Obviously the sort of consent, POPIA issues, maybe just touch on that, maybe Esme as well. But
I really would think that the reasonableness is the part that is important, because in an emergency and you're working with a sick patient, the first point is really to deal with the emergency. And therefore, I would assume, Esme, that some of the requirements in terms of getting consents and collecting of the type of information and disseminating the information may not always be practical, like early in the morning in an emergency.
Absolutely. With emergencies, you actually always have other rules that apply, and you are going to try and do the best for the patient at that point. And you will even be able to collect information from other sources if the patient can't provide you with the information. So if there's something specific that specifically concerns you, just please highlight that. But I don't think it's going to stop you from treating the patient and doing the best you can in the circumstances, and using information to do just that.
Esme, you mentioned during your presentation the legitimate interest, I think you called it, or the legitimate interest clause. Is that the sort of not loophole, but the sort of clause that allows this sort of scenario to continue and ensure that the right thing is done?
Not entirely, Alex, because the legitimate interest clause only applies to information which is not special personal information or children's information. So as soon as you work with children, you can't use legitimate interest. And if you work, for example, with health information, you can't use legitimate interest. But the one thing you must remember, that all special personal information, all types, you can always process that if it's for the proper treatment and care of the patient. You don't need any consent for that. And if you are going to collect information from other parties to properly treat the patient, that will also be covered in POPI. So I don't think that should be a concern at all.
Thanks. Next question I'll read. It's a bit longer, so it's a multi-part question according to the requester regarding keeping of records. Patient records must be kept for at least 6 years after the last patient interaction. What if patients require further surgery after the files are destroyed, assuming POPIA has been complied with? Should we start with that one?
Yeah, so first of all, you must look, the guidelines are different from the Health Professions Council depending on the type of patient. So if we talk about adult patient, compos mentis, the guideline is 6 years after the record or that patient file has become dormant. So in actual fact, the patient hasn't been a patient of your practice. And you can still keep the information longer. That's not cast in concrete if there is a reason for you to have those records. There could be a lawful purpose that you can define your practice, or you may want to keep it for historical or statistical purposes. So one must be careful to say 6 years and then you destroy all the information. That's definitely not the guidelines. And as I've mentioned, there's not a timeline given in POPI. POPI gives you options, and you must select the best option in terms of your practice setting and the types of patients you have.
Just to add on that, the 6 years as you've described, Esme, I mean, the HPCSA gives very good guideline in terms of how long do you keep your records. For instance, obstetric records, you keep them longer, children's records, keep them longer, mental health records for life. So you would look at what is required and why do you still need to keep those records. So balance that with the requirements that are outlined by the HPCSA.
Thank you. The second question, is written consent required from patients before the records may be destroyed?
It's not a requirement for POPI. So first of all, you must make sure that you can destroy it. There's not going to be a comeback. You can, if you want, advise patients how long you will keep their records, or, you know, after which you destroy. You also could invite them to come and have their records or take their records if you want to destroy them. So but it's not a requirement in the practice. Well, in POPI. POPI just says if you may no longer keep the records. If you've determined a period or a purpose and you may no longer keep it after that, then you either destroy or you can even de-identify. That's also an option where you take all the identifying information away and just keep the rest, maybe for research or whatever purpose. But yeah, written consent is not a requirement.
Thanks. The third part of this question, must records be destroyed if the patients demand so, even if no statutory limit has been reached?
Definitely not. So you must then justify why you will not destroy it and why you may lawfully keep it. Remember, in the National Health Act, it's an obligation for you to keep medical records. So you can't just destroy it if anybody wants that to be destroyed. And hence you have to have a record keeping and a policy in place so that you can justify why you will not destroy those records and that you may lawfully still retain them.
Yeah. Question 4, and Chlombe, maybe to you. I think you touched on it, but perhaps the precision of this question. How long should records of children minors be kept? 18, 21, or 6 years after they become an adult?
I think the HPCSA guideline gives a very clear indication that children's records up to 21 years, you should keep that. Mental health for life. And all others, it's 6 years. From a date which they became dormant, meaning that you can have a patient that you don't see for 5 years, 11 months, and that patient starts coming into your practice on the 12th month of the 6th year, then you still have to keep that record for a further 6 years before you say it has been dormant. But with children, I mean, I think JP or Esme will correct me. Children, 21 years. Obstetric records, 21 years. Mental health for life. Or if the person that at the time you were treating the person, it was a mental health matter, you keep it for life. But HPCS has got a very good guideline.
Thank you. Question 5, what happens if a patient litigates after a record has been destroyed? It's a pity JP's fallen off. Unfortunately, he's had load shedding kick in, so stage 4 messed up our plans a little bit tonight, but between us, we'll try and answer all the questions. Flombe, do you have a sense?
I think JP, Alex, I think JP is back. Is he not back?
Yeah.
JP, are you back? I saw his name for a second, but I think he fell off again. But Flombe, maybe if you'll have a go. What happens if a patient litigates?
I think there are two things in my understanding, Esme. Firstly, you would keep the records according to the requirements of the HPCSA. And the litigation has got the prescription period. Definitely when you destroy those records and nothing has come, the probability is that the case would have prescribed anyway, because prescription is less than the period where you are needed to keep the records. So you would keep the records according to the requirements of the HPCSA. If nothing has happened and the patient comes in and starts to litigate, probably the case would have been prescribed. Esme? Remember, I'm not a lawyer.
No, you're spot on. And the African Council guidelines actually take cognizance of the prescription periods. And that's why they have those time periods that they recommend. It's exactly because of that. So that you don't destroy a record before a claim has prescribed and then you can't defend yourself. So it's very important that you consider that in your record keeping policy.
Thank you. Next question is just, does EthiQal cover me with advice if there's a complaint against me in case of a complaint? I presume that's in the POPIA space. I'll just answer that. JP is the right person, but he's away. I would say yes, it does. We move to the next one. We'll rather use 5 years as a minimum for record keeping. I think this is probably more of a chat scenario. I think we've discussed sort of the timelines for keeping records, so I'll move on. Next question, does one have to keep physical file or electronic will suffice? Of course, if it follows security protocols.
Absolutely, you can keep electronic records nowadays, Electronic Communications and Transactions Act. So it must follow the security protocols and also, you know, be actually, you must be able to use it as proof in a court. And that act gives requirements, but as a principle, you can keep records electronically.
And the next question was similar to the first one around providing practice with a file that contains the documents. Certainly, I've mentioned we'll provide some further support to our policyholders. I will just mention that Esme also does provide support in the industry, so you could try contact, or could contact Esme as well. In terms of the next one, from Keith, if a patient refuses to sign these documents, can we refuse to see the patient?
Yeah, you must remember there are only certain instances where you can't refuse to treat a patient or see a patient. So it's in an emergency or where the patient is under your treatment and care and you can't safely transfer them. So if there's no scenario such as that and it's a new patient, if they're not willing to accept your terms and conditions in the way that you practice, then obviously you don't need to treat them. It doesn't mean that the patient's not going to take this further and go and complain to the Health Professions Council, etc. But there's definitely in law no reason why you cannot tell the patient to rather than find another practitioner.
Thank you. Next question. Is anything unsafe in using a dedicated practice Gmail address for communication with patients?
I'm not a security expert or an IT expert, but my understanding is, and I'm aware of these cases, that Gmail is not necessarily secure. I would rather that an IT expert advises you on this, but I feel uncomfortable with a Gmail address as a secure address.
That was a very important question, because in contacting the doctors, you'd find that it's a Hotmail, it's Yahoo, it's Gmail, and I think we just need to have a look at that more carefully now, from a doctor's perspective.
May I also add that often this type of information is not stored in South Africa. So it's also a question that you need to ask. If you use an address like that, where is your information actually? Is it in the United States, for example? And then you have other complications under the law.
Thanks, Esmen. I also get a sense that often the sort of free software potentially is more problematic compared to their corporate versions, the paid-for versions. And I think the paid-for versions are typically more secure and protected. So it's worth investigating that as a solution. Okay, move to the next one. I'll just read it again. My patient sent an email to say she has immigrated and is requesting her obstetric notes to give to her new doctor. She wants these documents emailed to her. What are my options in this case?
So the first important thing is the information will be supplied to the patient herself. And that is in order, because it's the consent. You need a consent basis. So it's not going to a third party. So now in terms of email, you know, these things are not always secure, but the law says we must take reasonable security measures. So I think you must just make absolutely sure that you are sending it to the correct address and to verify that it is the address of the patient. Encryption is not always possible for you. I think we're going to move into an environment where we are going to start possibly use password protection for sensitive type of information that we send electronically. That would be a better option, but it's not necessarily practical. So you must also look what is practical in your practice, but make absolutely sure of the recipient and the recipient's address.
Thanks, Esme. Just a quick time check. I see we're still getting quite a stream of questions coming through. So if we don't mind, we'll try to keep going on a few more minutes and try and tackle as many questions as we can. But perhaps at some point we might just have to end the webinar, and then we'll come back on each question directly to those that have asked those questions. So, but if it's okay, Esme and Chlumbe, if we do a few more minutes, thanks. Yeah. Next one. If a patient from SA receives medical care in a foreign country and requires some information from his or her doctor, who is based in South Africa, who has to give consent?
Well, just to clarify the question, if the patient asks for the information, then the patient is actually providing that consent. If the doctor, the treating doctor, is asking for the information, then they would need to provide the consent that you can provide it to the third party. But immediately, if you provide to a third party, and it's health information, for example, you need to know whether there's security in that country or a secure environment for data protection. Otherwise, you sit with a pre-authorization process at hand. With the information regulator. So it's better if you can actually provide the information directly to the patient.
Thanks, Esme. Yeah, I think that does seem to be a key thing. If it's straight to the patient, it helps avoid a lot of issues. Next question. I'll read it as it's written. Is this not a risk to the practice to appoint an officer or default officer if appointed member is not equipped to deal with the requirements of the POPI Act? Will the risk shift to the appointed officer? What protection does the officer have?
It is very important that whoever assumes that role must be trained and must understand what the requirements under POPI are. I think it's actually a greater risk if you take somebody from the outside who does not understand what's happening in your practice, and it's going to cost you money because those people can incur personal liability. So for anybody from the outside to take on that risk is going to come at a cost. So it's better if you can keep it within your practice, but make sure that whoever that is, be it yourself or another staff member, actually undergo training so that you are equipped to deal with this. The accountability still remains with the practice. The accountability does not shift to the information officer. However, if the information officer does not discharge his or her responsibilities under POPI or POPIA, there could be even personal liability for them. But compliance with POPI remains with the practice, the responsible party.
Thank you. I think, Slombe, maybe the next one to you, just the word, how it's read, I'll read it as it states and just see if we can understand it, but can I get legal advice before handing records to patient, for example, MPS? I'm not sure if that last bit is for patient to hand over to MPS, or but certainly can I get legal advice before handing records to a patient?
Yeah, I think that's a very good question in a sense that we do find that some of the doctors would send information to lawyers or to other people who have requested the information. It's always a very good first step to do. You will get the legal advice.
Okay. Next question. What happens if you refer the patient to Dr. A, but they decide to go to Dr. B and you're not aware of this? And I presume confidential information is traveling across from Dr. A to Dr. B.
Yeah, so obviously the patient has the choice whom they want to consult or where they want to go. So you can't really control that. You can make a recommendation. I think ideally is that you either send the referral letter or the referral note with the patient's consent to the referring or the practitioner you refer to. But I think the easiest way here is to give the referral letter actually to the patient. Then you don't have that risk that you share information with somebody without consent of the patient.
Thanks.
And I think that is that's a very important point, in a sense that, you know, patients would ask the doctor, who is the best, or who do you use normally? Then you would recommend, say, this is the doctor that we work with, but it always works if you give it to the patient. And the patient may decide to go or not to go. I mean, I just want to make an example around, you know, a lot of obstetricians that would send patients for, say, fetal anomaly scans, where you would say, this is recommended, you need to do it, but the patients decide not to. So it's always better to give the referral to the patient.
Thank you, Slombe. Next one, multidisciplinary teams. These have for several years been regarded internationally and locally as optimal practice for making decisions regarding management of, for example, patients. Some members of the team will not have personally been consulted by the patient. Furthermore, pathologists, radiologists, etc., may be part of the team. Does POPIA render these multidisciplinary teams illegal? Or maybe, if, in my words, does POPIA render them to breach the Act, in a sense?
If I can just take it first, Esme. I think within the POPI Act, there are some exclusions. And if that information is shared in the interest of the patient or during the course of actually treating the patient, that information can be shared with the practitioners that are participating in the management of that patient. And I just want to emphasize this point, because I would see on the WhatsApp groups that, you know, there's some discussions about a patient, and I'm sitting somewhere in Pretoria, and this patient is somewhere in Lusikisiki, and I'm not involved in the care of that patient. The fact that I'm a doctor doesn't give me a right to know the status of that patient. Therefore, in multidisciplinary teams, you can share that information without getting the consent of the patient if it is in the interest or those health practitioners are directly involved in managing the case. I hope I'm correct, Esme. If I'm wrong, please correct me.
No, I think you're spot on. So you must also remember that POPI does not negate other legal rules. So in the National Health Act, there is a provision that you can share information with another healthcare practitioner, for example, if there's a legitimate interest and it's in the interest of the patient. So that even gives you that authority. But as Dr. Schlombe has said, you must be careful with whom you share. You can't just share with a practitioner because they're a healthcare practitioner and if they're not involved at all. So rather consider that you then describe the scenario or the situation or the symptoms instead of disclosing the patient's identity and other identifiers about the patient. So depending on the circumstances, I think rather look at it as a case with people who aren't involved than sharing specific patient information.
Thanks, Isabel Schlombe. It almost seems to answer a bit of the next question as well, which talks about sending a report to a referring doctor. Am I right? It's effectively, you've answered it, same scenario where instead of a multidisciplinary team, a referring doctor in a sense is part of that kind of multidisciplinary team in a different fashion, but the same answer would apply in this case, if I'm correct?
Yeah.
Yes. Thanks. The next one is similar, I think, and it talks to if a patient is very sick and we need to discuss with the family, how do we proceed? The patient maybe is not able to give any consent. Just discussing with family members.
Yeah, I think that's important because that's where, you know, in the take on, that's when it's very clearly defined who the next of kin is, or in a case of emergency, who do we need to contact. But the other important one is that it seems like you need to be clear that in the hierarchy of the family members, who's got a right to give consent when the primary patient is unable to give consent. So it's a very important one, and it's a very difficult one in, you know, extended families or in broader families, because it's not always the husband that has to give consent to the wife. It could be the mother, it could be the father. So the context of that patient is very important, but I know that the law is very clear to say your partner or whoever you've nominated, I mean, as the person who can give you the, you know, the consent if this patient is unable to give consent, but practically it's not as easy. But what I always give as an advice is to say, if you've deviated from what is prescribed in law, write the reasons down. This is the context, this is how it was done, this is the reason why this consent was given by, so that you defend the reasons for not following what is strictly prescribed by law. Esme?
I agree with you. I think, you know, the National Health Act again allows for proxy consent and family members to consent in a particular priority order. So there are options to deal with this situation, but yes, I take your point that it might be difficult in certain circumstances. Just follow the law and yeah, then you should be actually fine from that.
Thank you very much, Esme Schlombe. I think we must call it an evening. It's been
Alex, just one last question, and it's a question that I really would want to ask, and I'm really holding a flag up for doctors. It happens sometimes that you would give a patient your cell phone number as a doctor, which is normally not it's not the practice, and it's not in the public domain, because, you know, the names and the practice numbers and probably the office numbers are in the public domain. You give this patient, because you are treating him or her, your personal phone number. And you say, please, if you've got any need based on your condition, you please use it. Then the patient is gone and is fine, and the patient now is somewhere else, and he calls you and says, please, can I come on Monday for this and that? Can I take that patient on, Esme, and say, you are now breaking the consent and I take action against the patient?
Yeah, this is a difficult one if you've shared the information with them and they might have forgotten the rules around that. But let me end on a positive note. So as many obligations you have now in respect of patients and in respect of your employees and other data subjects, you also have protection as a data subject under the law. So if other people use and abuse your information unlawfully or against what is in the law, you can use POPI to protect yourself.
Thank you. I needed to hear that.
Great. Thanks, Swambi. Thanks very much, Esme, as our guest this evening. I think, yeah, there are many questions still, and I think we will get in reply to those to the individuals. We also have a short survey at the end of this as you end this webinar. So please do answer some of our questions. We'd just like to get some feedback, please. And there's also an opportunity to send any additional questions, or if you'd like us to contact you to help, please do that in the survey. But as I said, we will be sharing this webinar, this video on our website probably next week, and supporting information around this. If you do want our further support, please do it in the survey that will follow. Last reminder, this is an ethics CPD point, so that we will be giving out those certificates next week. Thank you, everyone. Thank you, all the attendees. Thank you, the presenters. It's been a great evening and discussion. Keep well.